and ACM. I'm the co-moderator. The Holy Roman Empire was a misnomer because it was not an empire. It was German and certainly never holy. Which brings us to AMAL, Association of Muslim Accountants and Lawyers, which has non-Muslim members. Indeed, we had a Hindu female office bearer in the Youth League, and has members from business and non-professionals. So why Muslim? Muslims face challenges. For instance, interest is taboo. So Islamic banking. The chair of AMAL is also CEO of Al Baraka Islamic Bank, SA, which has just been named world's best Islamic financial institution. The Al Baraka Group is in 17 countries in Africa. Likewise, marriage, inheritance, organ donation, etc., all require professional expertise, which AMAL provides. Corruption in South Africa is both in the public and private sector, and it's endemic. Deputy Justice, Chief Justice Zondo identified whistleblowing as crucial to exposing corruption. The active citizens movement is an oxymoron because in truth, it is hyperactive. ACM, in collaboration with a body of whistleblowers, responding to a request from Zondo, submitted a report to the Commission proposing improvements to our legislation, plus other key safeguards. Shabir, if you could block out some of the faces, it's a family show, and we cannot have traditional leader backgrounds waltzing onto our webinar screen. There have been some last-minute changes. The two advocates excused themselves, and Willie Hofmeyer and Shavira Devachandar have kindly stepped in and more than compensate. Martha Ngoi has had 3 deaths in the family recently, the matriarch of the family only this week. Our condolences to her and her family. Yet she still submitted a report which Fani Dingiswayo will read on her behalf. I will not dishonor our whistleblowers by categorizing them with dog whistle Trump. To set the stage, by briefly touching on the current legislation, are our legal researchers. First, Christelle Semolina, Selamaya. Christelle is a law student and a member of the vibrant ACM Youth League. Pops Rampersad, who I can see on screen, and I are EXCO members of ACM, and we both co-chaired the ACM Come Whistleblowers team. Pops, I think we are dealing with state capture and the Zondo Commission. And the next line, nobody understands, it's a play on what went viral, so a big LOL. Pops, if you overstay your time limit, I'm going to tell you to shut up. Now, take off that orange mask from your face. Over to you, Pops.
Okay, good morning, friends and colleagues. Something that you would know, Aslam, is that it's very difficult to get me to shut up. So, but I'll try. But for starters, let me say, personally, and my organization, the Active Citizens Movement, we stand in solidarity with the people of Palestine. We cannot forget the injustices that is being perpetuated against them. I am Pops Rampersad, an executive member of the Active Citizens Movement. Building on the orange overalls, the orange mask is a campaign of the Active Citizens Movement that went national. ACM encourages each citizen to raise awareness against corruption by wearing an orange mask every Friday. And we encourage everyone participating today, either in the audience or participants, to wear that orange mask. Whistleblowing legislation is contained in our Constitution. The Companies Act, the Protection Against Harassment Act, or PAHA, the Labor Relations Act, but principally the Protected Disclosures Act, or PDA, as it's commonly called. The Whistleblowers Act. PDA defines the relevant concepts and provides avenues of reporting by and protection for whistleblowers. PDA applies to employers and employees in both the public and private sectors. PDA exclude, amongst others, trustees, volunteers, consultants, and independent contractors. I hand you over to my co-presenter, Christel Salamaya.
Good day to all. The main aim of PDA is to encourage whistleblowers by protecting them from being subjected to occupational detriment in their work environment. The protections offered under the PDA apply only where a protected disclosure is made about impropriety to the right person, example to your employer or the public protector. The court of jurisdiction is largely the labor court. Relief for the employee is financial compensation and transfer on terms no less favorable. Incidentally, a confidentiality clause in an employment contract is void to the extent that it conflicts with PDA's protection.
PDA obliges internal procedures to be exhausted before disclosures is made further. The first port of call is to your employer, often the actual perpetrator, which results in your cover being blown and exposing the employee to financial, physical, and other prejudice. The perpetrator often becomes judge, jury, and executioner by utilizing the internal disciplinary procedures. The imbalance of power and resources is stacked heavily in favor of the oppressor. The result is that in practice, our legislation affords little protection or encouragement to whistleblowing.
Housing whistleblowing legislation within the Labor Relations Act, or LRA, is a serious impediment. Despite the legislation, whistleblowers are put through trumped-up disciplinary processes or the High Court. The Labor Court, being a creature of statute, has only selected remedies and powers. It lacks the power to deal with the common law or other statutory remedies. Labor tribunals are ill-equipped to deal with the fundamentally guaranteed rights, navigating through the minefield of complex, intertwined legislation, when every technical defense is raised by highly paid senior counsel, is intimidating. It is but a few civic-minded brave hearts who have endurance, resolve, mental and financial ability to fight against overwhelming odds. Lack of financial resources to engage competent lawyers leads to loss of jobs and livelihood. Families break up, threats of violence are made to whistleblowers and their families. Some have been murdered, others have fled the country. Some have committed suicide. South Africans are hugely indebted to our courageous whistleblowing heroes.
I'd like to introduce our first hero for today, Adila Chauhan. Adila is a chartered accountant and an advocate of the High Court. Adila, I think it's high time that you join the AMAL group. So Mark Lamberti grew Massmart from 6 underperforming stores to Africa's 3rd largest retailer with 238 stores in 14 countries in Sub-Sahara.
Adila's story begins when Wiz guy, Mark, was head of a subsidiary of Imperial Holdings. The head of Imperial warned Adila that it would be a career-limiting move if she raised a grievance against such a powerful man. Mark was oblivious that you do not strike a rock. Undeterred, Adila gave Lamberti and Imperial a tight club, literally a tight club. When the High Court found the remarks racist and sexist, resulting in the great Mark Lamberti having to resign in disgrace.
Adila, if you can unmute yourself. Is Adila in?
Yeah. I'm in. Good morning, everyone.
Go ahead, Adila.
Good morning, everyone. In 2015, I blew the whistle on racial discrimination within the group of Imperial Holdings. Basically, they were employing white male into senior executive positions. There was lack of transformation within the entire group. When I joined in 2012, I was appointed the group financial manager. And at that point, I had inquired regarding progression within the group. And I was informed that there would be sufficient opportunities within a listed organization, Imperial Holdings. During the latter part of 2012, a white male was appointed, Peter Hibbert, as the CFO of Associated Motor Holdings. And he was basically supposed to be there for a one-year contract. And I was supposed to take over the position after his 1 year was completed. Peter Hibbert requested that I go through a psychometric test, which I attended to, and I actually achieved the desired results. And he was quite comfortable that I would be able to take over the reins from him. In around 2014, Mr. Lamberti was appointed as the CEO of Imperial Holdings Group. And when he joined, he requested that the position of the CFO be advertised. And I was subjected to an interview with Mr. Lamberti, which he later denied. And during the interview process, he advised me that I was not the candidate that he was looking for. In a subsequent meeting with Mr. Lamberti and quite a few male executives, Mr. Lamberti addressed me as a Black female employment equity candidate. And I actually took offense at it, and I was really broken because I'm a chartered accountant. There was no recognition for me being a chartered accountant. It was just person of color, employment equity that was sitting in front of Mr. Lamberti. I raised the complaint with
Adila,
sorry?
Adila.
Yeah.
Adila, before you go on, there's a request that, you've got the light shining behind you, and they can't see your face, and they would like to see your face. So if you can sort on, if it causes too much delay, let's move on. But just to quote Lamberti, his actual words to quote him: "You're Black, you're female, you're employment equity, you're technically competent. I would like to keep you, but if you want to go, go." Carry on, Adila.
Thank you, Aslam. I then raised a grievance with the chairman of the board of Imperial Holdings, and unfortunately, the grievance was not well received. And another unfortunate aspect is that the investigation was undertaken by Mr. Lamberti himself. He brought in his own lawyers, and a manipulated grievance procedure, or lack of grievance procedure, more an investigation into myself was undertaken. And basically, I was subjected to a manipulated disciplinary procedure with a desired outcome. And I was basically dismissed after that. I then pursued the matter through the High Court. Unfortunately, I had a very good legal team. Shavira and Darlene Pofo helped me through my entire matter, and we came out very successful. But I must admit, it's when a person in power is managing the entire process, when someone raises or blows the whistle, there was no independence in the investigation. You're basically being set up to be dismissed. And the HR manager was also key in working with Mr. Lamberti in getting me dismissed. And I guess for me, it was not I was not going to let anyone destroy my career. And it was also to ensure that people are not subjected to the same course of action that I was put through. So that is basically my journey. And I was fortunate, it was a very expensive journey, but a very successful journey to have gone through.
You mentioned earlier some details of what you have discovered. In discovery, certain things came out. I don't know if you're going to deal with that, Adila?
Yeah, sure. During the discovery, what had transpired was the HR manager had participated in the investigation, and he had met with Mr. Lambati and the lawyer and Ockert Janse van Rensburg, and they had orchestrated what they wanted to achieve at the end of the investigation and the disciplinary hearing. It was also the fact that the Imperial Board was not involved with the investigation because Mr. Lambati had appointed his lawyers to investigate the process.
Okay. You also mentioned that besides the company, closing ranks against you, your colleagues your work colleagues also didn't give you any help and assistance. I think you want to deal with that as well.
Sure. When I blew the whistle, I must admit people that I trusted and expected them to be honest, they actually gave negative feedback on myself, and I had no support from people that I had trusted, which included the Chief Executive Officer of Associated Motor Holdings, Mr. Manuel Decana.
And being dismissed, what exactly, you won your case, but how do you rebuild a life? Surely nobody would want to employ. I mean, a whistleblower is normally unemployable because nobody wants somebody who's problematic. Have you found that to be the case, and what have you been able to refashion your life to do?
To be honest, it does have a significant impact on your life, both from a health perspective, from a careers perspective. It's even though the High Court exonerated me, there are definitely entities out there in the private sector that would not employ me. I have applied in a number of instances and I have been unsuccessful. I've re-engineered myself, if I can say it. I studied further to do law and I finished my pupillage last year and I qualified as an advocate. Be complementing my chartered accountant now with being an advocate. It is quite a successful turnaround, but I don't think many whistleblowers would have been as fortunate as I have been. So it is definitely something I think, the Protected Disclosure Act does not address in terms of whistleblowers, in terms of them being victimized, and there is no recourse for them. And the unfortunate bit is the perpetrators are the ones that continue to hold their positions. And as they move on with life, like nothing happened.
And you won your case. The fact that there was no transformation was proven. Has that had an impact on the way going forward for Imperial Holdings?
I can say with certainty that no, that organization is not transformed, and I'm basing this on their latest annual report, which I reviewed. The positions are predominantly still held by white male. If you look at the senior executive or the CEO of Kia, the CEO of Hyundai, the CEO of Renault, the CEO of aftermarkets, they are all held by white males. The organization still lacks transformation. I reported this in 2015. In 2021, transformation seems non-existent.
Okay. Fatima, if you can come in.
I'd like to introduce our next panelist, Shavira Davatandra. She was the attorney who successfully represented Adila in this matter. Shavira, you are a labor law expert. Do you agree with ACM that locating PDA within the Labor Relations Act is a serious impediment?
If you can unmute
Shavira,
yourself.
can you please unmute yourself?
Good morning. Fatima, I just wanted to clarify with you before I answer. In what way is the ACM stipulating that it's an impediment?
Well, the fact that it's got to go through the labor relations disciplinary process and you go through an internal procedure, which automatically exposes you, your cover is blown, and exactly what's happened to all the whistleblowers that we see. And a prime example, you victimize, you lose your job in business as usual. So we feel that that is a problem. Over to you.
Sorry, do you mean the disciplinary process in the sense that they have to hold a disciplinary hearing and investigate in that way? Or do you mean that the provision for the PDA is contained in the LRA?
Well, the system as it is does not work. And instead of there being maybe an ombud or some independent body that one could go to, you've got to go through this channel, which is not working.
Okay, so my understanding at the moment is, as it stands, is the reason why they've put it in the LRA is because as PDA is at the moment, you can approach both the High Court or the other courts, or you can go through the CCMA. The reason why I think it is beneficial at the moment to have it in the CCMA as well as in a way where you can go through normal litigation is because for the ordinary employee to be able to, commence litigation in, like, for example, a high court like Adila did, where we went along the lines of an unlawful dismissal instead of an unfair dismissal, is very costly. So for the average employee, they wouldn't actually be able to even get any recourse if there was no provision in the LRA to include a protected disclosure under the definition of an unfair dismissal.
Okay. Fatima, if you can go on to the next point, I just need to make some time, so I'll skip my question if you raise the next one.
Thank you. So, Severa, while I'm not inquiring into what you charged Adila, I just raised a general question. Normally, a litigant who wins a matter can recover only a portion of their legal fees and their advocate's fees. As a general rule, what percentage would usually be recovered from these exorbitant fees that one would have to pay?
Okay, so for the advocate, you usually get their full fee. The cost of counsel is normally awarded, whatever the invoice, and then for the attorney, you can get anything between 1 to 2/3 back of what their fees were.
We'll now go on to the next one. Our next panelist is Cynthia Stimple. Pay now and with luck fly later. SAA did not invent corruption, but may have gone some way to perfect it. Now, Cynthia lost her job, even though she saved SAA 256 million. Now, if she remained silent, presumably government would simply have increased the bailout by 256 million. Now, this is how it seems how punch drunk we've become. Somebody saves 256 million, they lose their job, everybody carries on. Over to you, Crystal.
Cynthia's testimony is a common thread of outsourcing simple tasks instead of utilizing internal employees at minimal or no cost to the taxpayer. Millions blown irregularly on outside firms to coordinate the minister's media briefings. Millions outsourced without tender to distribute money to artists. And this is the tip of the iceberg. No one to blame. Cynthia, forget the whistle. You must awaken the public from their slumber with a vuvuzela. Over to you, Cynthia.
Good morning, all, and thank you for having me. So just to give an overview and a background of myself is that I am married. My husband's name is Michael. I have 2 children, Nicole and Jacqueline, and I have 2 grandchildren, Noah and Emma, from my eldest daughter. I also am a wife, as I said, from my husband. I'm a mother, I am a friend, I am an auntie, I am more than just the whistleblower that everyone puts that tag on us. They identify us as this whistleblower and they forget that we are real people beneath that title. I've been an employer as well as running my own business. I've also been a manager as well as a clerk. So I've gone through the whole range. My background started in banking when I left school and matriculated in 1974. And because I applied to go to university, I had a good matric pass, applied for medicine at Wits. At the time, I needed a ministerial consent, which I didn't receive. They said I have to go and study in the Cape at Belleville University, being a colored, identified and classified as a colored apartheid years. And my parents couldn't afford to send me there. And my dad picked up in the newspapers that they were now employing non-whites into the banking sphere. And that's where I went. So I studied throughout my career. I studied up to an MBA. I studied part-time. So my background has been in banking. I started in the normal retail banking, moved into merchant banking, moved into corporate banking. I've learned derivatives. I've spent lots of time in Citibank in the treasury. And so until I reached the point as group treasurer at SAA. And it was in that time when I was at SAA and got promoted in that position as group treasurer, I thought, wow, I made it. I've got this final pinnacle in my career and that I will be able to retire debt-free and have a relaxed retirement time. But within that last 2 years is when I picked up behavior that was not conducive to what we taught in our corporate environment, in our policies and in our procedures. And with that was when I decided I need to speak out and stand up.
Thank you so much, Cynthia. That is actually a very interesting background, and you're right, you're definitely more than just a whistleblower. Cynthia, can you please take us through exactly what the issue was at SAA?
Thank you. So SAA at the time when I joined was the end of 2006 into 2017. To be a going concern, SAA had to borrow funds. On the back of that, they were very strong in assets up to 2000 in that they owned all the aircraft, they owned the airports, but they had very little cash flow going for them. During that time, around the 2000s, they had hired a new CEO who sold all the assets. So for instance, the airports are now owned by Airports Company. And so that background and SA then went into a position of having cash in the bank, but no assets. By the time it got to 2006, they'd utilized all that cash and were now needing additional cash flow. The National Treasury provides a government guarantee to most state-owned entities. So, you know, Eskom has the same, so does Denel, so does DBSA, Transnet, and SAA was no different. Their first government guarantee came in 2007, March, of 1.3 billion. And we then as Treasury, that is our job, is to go and source the funding, where we put out a request to the banks, and the banks assist in the funding. If you go and purchase a house or a car, where would you go? You would go to a bank for that funding. And we do very much the same as SAA, and that was done. So we borrowed these funds. At the time we started with 1.7, we reached to almost 15 billion by the time we were into 2015. By then, the group treasurer had resigned. I'd always deputized since I started there, whoever the group treasurer was. And at that time, I was deputizing again. And with that, I had to prepare a borrowing plan for the National Treasury to approve. And they had to look at what our future dates would look like. Would we be a going concern, etc.? And that was done in the borrowing plan, which in effect doesn't only cover what you're borrowing, it also looks at what's the cost going to be in the future for your aircraft, your leases that we needed to pay, your staffing costs. So all costs are encapsulated in this borrowing plan. and which was approved. And we also recommended that we should consolidate the debt. The recommendation for that was that we were paying at least a minimum of 1.2 to 1.3 billion per year in interest paid, and we wanted to save that cost for SA. And it was based on that we went ahead with the consolidation of the debt. However, our board at the time wanted to get involved with the consolidation and said to us that they would like to be part of the RFP process, and then B, they also wanted to give suppliers to that, make recommendations. So there was my first concern, first red flag, and I raised that with my senior CFO, who was Wolf Mayat at the time. And I said, this cannot be. Board has oversight. They should not be getting involved in operational matters. This is what we do. And we normally make the recommendations, and they can then give it back to us and tell us to do further research or investigations, etc. However, he was equally concerned and said, look, this is my challenge that I've been having at board, and he was going to be resigning. So with that, I raised the concerns with our board through a letter stating to them that they should be having oversight. We do have it. If there is any other recommendations that they have, they can put it in writing to us. We will investigate it. Obviously, my letter was ignored. I then asked, we sent out a RFP. We took into account the board's recommendation, the board's clients, which were minor clients, and my boss then said to me that they wouldn't meet the criteria anyway because they don't have big balance sheets. Strange enough, once we sent it, the banks obviously didn't want to take a huge risk with SA, so they gave smaller amounts. They wouldn't take the full 15 billion, which is also understandable. And the majority, 3 banks came in with 1 billion, 1.5, etc., the total being 4.5. And a client came in by the name of Seacrest that they were prepared to pay SA a full 15 billion at interest rate of 5.8%, at a long-term tenure of 10 years, but a 5-year grace period. That obviously was too good to be true. And we raised it and we discussed it in our risk committees, and we said, who is this client? Where are they getting the money from? And we asked our legal department to do a due diligence on them, which they did. The client failed. They passed their own within their small company being Seacrest, but they were getting their funding from a client, Grisak, and Grisak was based in the Free State, and the directors, one was a Russian director and the other was a South African director. And obviously the legal department had gone to ask them to give full disclosure of what the bank statements were, disclosure of what their financials were, and they refused to disclose that. So obviously we couldn't recommend them. And we stated to board, we can, these were the clients that came out top, but we cannot go with them because these are the very reasons, as I explained to you. And then we recommended going again with the banks, and the total amount was 4.5. What our board did then, and that was the next red flag that came out for me and stood out as bright as sunshine, that they put forward and recommended in a board resolution that we should go ahead with FDC, being Free State Development Corporate, get them to fund SA a full 15 billion. And they qualify this or justify it in the board resolution by a letter that was distributed at board. So immediately after this, I get called into a meeting and asked to ratify the board's decision. And I refused. I said, I cannot do that. Firstly, this client wasn't part of the RFP process. Secondly, this client, can I see the letter? This client hasn't given a rate. They don't give a term sheet. They don't give us the data around this transaction. Anyway, board then said, well, the CFO, the new CFO instructed me that I need to follow this. So what I did was I said, let's send it out. let's ask them to, we first called a risk meeting and said, what's the easiest way? Let's stop the deal. Let's just rather start from scratch, or B, which was another recommendation from the rest of the risk team, is just send the RFP process and then reassess and reanalyze all the data. On that basis, to save time, we sent in the RFP. Yes.
Over 10 minutes, if you could, your interesting thing, but if you could just rush through, because I'll allow you 15 minutes and I'll have to move on to the speaker. So carry on. You've done 11 minutes. I'll stop at 15.
Okay, good. So thank you. That's done. Yeah, and so with the, just to put it in a nutshell, is that we did the assessment. The assessment came out that this client was parallel to the Secrets deal, exactly the same terms, 10 years, 15 billion, 5-year grace period, but the interest rate was 1%, 1.8% better, it was 4%. So obviously we felt there was something not kosher with this. We then took it to the CFO to discuss with her and saying, this is not, we can't take this to the board. We need to really start a new RFP process. Her advice to us was to leave it with her. In the meantime, in the background, they sought to get a transaction advisor via the procurement department. And this transaction advisor was chosen at a fee of 2.68 million rand. All the initial job was just to look at our loans and advise the board on what's expensive, which is work we already do, because we tell them these loans are maturing, these are expensive, we're going to renegotiate the rate. So it's work we already do in the Treasury Department. The job for the new transaction advisor was also to look at the loans and leases, the leases itself, the aircraft leases, and we have a department doing that. And then was to restructure the balance sheet, which has also been done. It was then that they chose this 2.68 BNP Capital at a price of 2.68 million. Once the client was chosen, they then changed the scope of the transaction that was tendered, or the procurement service, and said that this client must now source funds. When they changed that, I was called in to sign the document to say board has given approval for them to change this client's tender scope now. And when I looked at the fee was 300 million, meaning they wanted 3%, 2% of 15 billion, making it 300 million. It was subsequently changed to 1.5%. And in the end, though, the board still approved it to pay this client a total fee now of 256 million for sourcing of funds. And with that was when I decided that I should do something about it. Sorry, I think Fatima is going to ask.
You mentioned that, yeah, I don't know, I think we're almost out of time now. You received an award from the Airlines Pilot Association. There were a couple of, if you could just deal with that, and also the, how you were vindicated, and I think Praveen Gordon said something as well.
Yeah, so quickly in a nutshell, I did speak out. I spoke out to various National Treasury. I reported to Corruption Watch and to Public Protector, but I heard nothing. And then I was recommended to go to OUTA, which I did. And with that, we were able to stop the transaction from happening. So we saved them funds. They had to cancel that agreement with BNP Capital. The funds didn't flow. And yeah, so by then I'd left, I was suspended, and my case went on for almost a year, from July 2016 up to May 2017. in that SA just kept pushing it out. And eventually my lawyer advised, because I was 59 at the time, that I should just see if we could negotiate early retirement, which I did. And we signed just that I'm taking early retirement and I could keep my full pension, or rather my provident fund at the time. Speaking about the vindication and the awards, is that I was awarded by the APLA, which is the Airports Pilots Association. They're an international association, and we have a South African branch here. They recognize that I tried to save the airline some funds, and I did it in the way that I did. So I received award of integrity from them. And I also did a public speaking event with Daily Maverick, and there I was on the same platform as Praveen Gordhan. And he actually publicly said, he apologized that National Treasury at the time didn't consider or take my my whistleblowing serious, because they could have acted sooner. So, and he apologized for that and said, we need more people like Cynthia. Thank you.
All right. Thank you very much, Cynthia. Now move on to, Adila, Cynthia, and Martha have all teamed up with the Active Citizens Movement, which made submissions to the Zondo Commission on Protection of Whistleblowers. Martha Ngoyi was the Group Executive Legal Risk and Compliance at PRASA, whilst Lucky Montana was CEO. The contract to supply useless locomotives ballooned from 3.5 billion to 5 billion. Martha's objections were railroaded and sidetracked. Martha is still an employee at PRASA, but is currently fighting a legal battle, fighting for a job. Martha has submitted a report, which Fani Dingiswayo will read out. Fani, if you can unmute yourself and read out, and please try to keep as close as possible to the time limits. Thank you, Fani.
Thank you, Aslam. I'm just going to read what Martha wrote, which is captioned, "A capable professional turned into an accidental whistleblower." When I dreamed of my future as a contributor to the economy, I did not think of myself as someone who will be needing to blow the whistle on corruption perpetrated by some among the same people who gallantly fought against a system that muzzled dissent and fought for openness and democracy. Even the training that I received from university did not prepare me for fighting against people in leadership positions of my employer who had a difficulty with the values that I held dear and lived by, even though my employer's walls are adorned with beautifully framed statements of these values, and these statements of these values flower the glossy strategic plans of my employer. My expectation was that we are never going to have a fundamental difference about these values. We may differ slightly on what they mean, but we will not reach a point where I can safely say that ideals like honesty, integrity, Batubili, the rule of law, etc., are hollow platitudes bandied about by those who claim to have lost loved ones, limbs, and livelihoods to birth a nation that holds these ideals dear. After my university studies, I was blessed to get articles at one of the big 5 law firms in this country, a firm that calls itself today Africa's largest law firm. After receiving a good grounding at this firm, I was fortunate to work as a legal advisor at 2 of the major banks in this country. During my time with one of these banks, I spent some time in London training at Slaughter and May. Although these environments were led by white males, I was fortunate to be respected and given quality work and training. There would obviously be instances where my being a Black woman in pale male spaces would rear its ugly head and make me feel uncomfortable in these spaces. When an opportunity to work at Transnet came, I grabbed it with both hands. This was an exciting time for Transnet. It was shedding itself of dead weight that was in the old Transnet and was focusing on the business of freight and operating the ports. I was at the coalface of all this work. The then group CFO of Transnet, Mr. Chris Wells, gave a few of us who were Black women a chance to lead groundbreaking transactions, showed a lot of confidence in us and made us believe in ourselves. The opportunity to join PRASA placed me in the Swiss C-suite of a boutique professional organization, Intersight. At Intersight, we asked ourselves the question, how do we reduce the annual government subsidy to PRASA's commuters in a way that does not require the commuter to pay more? This question showed us that every weekday morning and every afternoon, PRASA transports more than 2 million people between major economic centers and their homes. We then started thinking about ways to monetize this. We found creative ways of monetizing this, of monetizing the numbers of people transported and the network of PRASA. With the assistance of the professionals at Intersight, in particular Intersight's CFO, Mr. Viresh Lachman, Intersight enjoyed clean audits for as long as I was at its helm. In September 2014, I joined PRASA from Intersight. This was a time of transition. Barely 2 months after I joined PRASA, I was asked to act as Group CEO for 2 months in December 2014 and January 2015. This was at a time when the board was considering massive modernization projects valued at almost 6 billion. I came in when a representation had been made to the board about the existence of certain reports. I had to revert to the board to tell them that the reports that they were told had been done could not have been done, and anyone who said they had been done was misleading the board. As a seasoned professional, I could not manufacture a non-existent report, and I could not stall the response to the board. I told the board the truth, and in so doing, placed a target on my back, a target that has remained to date. At PRASA, I led the Legal Risk and Compliance Department at the time of a thoroughgoing investigation that was supposed to be a turning point for PRASA. This was when big contracts were placed under scrutiny, were found to be gravely wanting, and the board decided to ask the court to review them and set them aside. This caused turbulence in PRASA. PRASA's board was dismissed by the minister. They successfully challenged this decision. They came back incorrect and left at the end of their term without having handed over this work to anyone. So who was left to deal with these contentious matters? The legal department under my leadership. If at this point the target on my back was not visible to some, the period that followed put bright neon lights on the target that was on my back, inviting all people who came to occupy leadership positions to believe that I had to be pushed out. The following successes inter alia of the legal department placed neon lights on the target that was already on my back. We refused to support the payment of 28 million to Prodigy and opposed the payment application launched by Prodigy against PRASA. We defended actions instituted by CIA companies claiming more than 60 million. A new chairperson of the board made a secret settlement with CIA companies, and the legal department went to court to reverse the secret settlement. To reverse the secret settlement when the funds were already attached by the sheriff. We lodged a claim against Sifambo's liquidators for the 2.4 billion that PRASA paid for the corrupt tender award that was set aside by the court. When the board spoke of a possible settlement, we insisted that any settlement should be sanctioned by a court. We testified in disciplinary proceedings that led to dismissals of PRASA employees who were involved in an agreement to invest 1 billion in the failed VBS Mutual Bank the Siangena awards that were tainted by corruption and irregularities, to mention a few. We advised the board of PRASA that a decision to terminate irregular security contracts without a contingency plan will be disastrous to the PRASA network. We advised the administrator that his appointment was unlawful 6 months before the court made this finding. All this was work that any capable, honest, and experienced professional in my position would have done. However, in PRASA, this work placed a bright target on my back and on the backs of anyone that is associated with me. The only reason this target is there is because it is important to those who want to steal to remove those who will prevent the stealing. Once these are removed, the message to the whole company is that people must be malleable to corruption to avoid being pushed out and their livelihoods adversely affected. A number of whistleblowers were pushed out of organizations that they served. People like my good friends Viswanathan Pillay and Johan van Locherenbeck did good work for SARS, and their good deeds did not go unpunished. They left SARS and became lepers. How they are still standing beggars belief and is a testament to the resilience of the human spirit. This is an inspiration that I live by. We have come to know Themba Maseko and Musilo Mutepu, who have kindly chronicled their experiences into books for posterity. These books for my country and Uncaptured are must-reads for all who care about whistleblowers. They too were pushed out because Musilo and Bianca Goodson were working for the capturers or private parties. Their good deeds, which were also punished, led to these private parties closing their doors. It is said that a gifted professional like Themba Maseko has not found work in 10 years. It is also said that Bianca has to ask for crowdfunding for her livelihood. These trailblazers, heroines, and heroes of our country cannot suffer after helping the country recover billions, collect billions in taxes, and save billions when they refuse to support corruption. There are many good citizens whose deeds were punished severely and Warren President said. It is now a matter of public record that on 28 January 2021, I was in a virtual board meeting having deliberations with the members of the board and my colleagues relating to some of the existential crises that PRASA was going through. On 29 January 2021, I received a letter terminating my employment on a lie that I had a fixed-term contract that had lapsed. This letter told me privately that PRASA would be suing me for 58 million paid to a company called SA Fencing Gate. As I was trying to get my head around these lies that were told to me privately, the board decided to issue a public statement containing these very lies. The public was told that I had overstayed my welcome at PRASA and used the instability at the board to do so, and that PRASA believed that it could institute legal proceedings against me for the 58 million contract to Fencing Gate. When this termination was challenged in court, PRASA could not find one person to state under oath these things that were sent to journalists all over the country and covered widely by the print and television media. In the litigation, they elected to rely on technical grounds. They lost. They made application for leave to appeal. We applied for our judgment to be implemented pending the outcome of the appeal. And in this application, asked the court to order the members of the board to pay the costs personally. PRASA agreed to the order that we sought and tendered costs, nothing said about members of the board, but they persisted with the application for leave to appeal. In another scathing judgment, PRASA lost the application for leave to appeal. PRASA has now petitioned the Labour Appeal Court for leave to appeal. This petition is pending. Another executive whose contract was said to have lapsed challenged the termination of the contract. PRASA lost and never appealed against the order in her favor. This is a very expensive matter for us. For those who are instructing lawyers against us, this is no skin off their teeth. PRASA is paying for all these legal battles. Inshallah, I am a whistleblower who is still employed. The attempts to push me out have not abated. At this stage, PRASA has increased the odds of dismissing me. If the petition fails, they hope that the disciplinary proceedings will succeed. At my core, I am simply a seasoned, capable, honest professional. I did not choose to be a whistleblower. Being a whistleblower chose me. After all, I'm a granddaughter of Mama Lillian Ngoyi and a daughter to Thomas and Dora Ngoyi. Thank you.
Thank you very much, Fani. We're going to be changing the order a little around a little bit. I want to bring in Coogan next. Fani, are you also at PRASA?
Well, I left PRASA at the end of January this year.
Okay. The judge ruled that it was a corrupt tender process. He declared the contract illegal, and he said that the decision makers must be held to account to deter public administrators from similar misconduct. Despite the Hawks investigating for 4 years, not a single crook has been brought to book. PRASA is still continuing with the illegal toll trains contract, will not recover the 2.2 billion it is owed by Swifambo because they say the legal costs will be too large. Yet PRASA has enough money to chuck on legal costs chasing Martha, who was the one person who exposed the criminality. I'm going to ask Pops if you can come in and introduce Coogan. We just from a time point of view, we'll come back to the international law later. But if you can deal with Coogan, and then we'll do Willie, and time permitting, we'll come back to the international law. Over to you, Pops.
Thank you, Aslam. Before I continue, there's a few questions that are on the chat, so I hope you get sight of those questions. Coogan Pere is currently working closely with a few whistleblowers, amongst them Athol Williams, who gave evidence against Bain at the State Capture Commission. It's my pleasure now to call upon Coogan to do a presentation.
Lovely. Thanks for the introduction, Pops, and morning, colleagues. Just a brief introduction on myself. My background is in strategy development and implementation, good governance and human rights. I served previously on the advisory board of the former public protector Thuli Madonsela, and more recently served in the presidency and the SRU in helping finalize the National Anti-Corruption Strategy, which has been signed by the President October last year. I'm in Johannesburg at the moment, where it's freezing, but I hail from Port Shepstone, rural KwaZulu-Natal, and not very far from me in Port Shepstone, many of you might remember Sindisa Makaka, the former ANC Youth League Secretary General, who was gunned down for exposing corruption. And further north in Durban, we had Tabiso Zulu, who was on the run after exposing corruption, and then subsequently was in discussion with the Human Rights Commission and Department of Justice on engaging with the Witness Protection Program. So briefly, colleagues, having heard those elaborate presentations from my colleagues, no doubt the true patriots or the true heroes are our whistleblowers. So my job then is, shortly on the governance and human rights side, is how do we honor our whistleblowers? We look at how did we get here, where did we go wrong? And how do we go about as civil society in fixing and rebuilding the country post-state capture. And in that regard, how do we honor Madiba's 1994 legacy of freedom, dignity, and equality for all? And in that way, help prevent a repetition of state capture and prevent state failure, as we've seen in parts of the continent like Zimbabwe and other parts of the world. So briefly, in terms of what I'm talking today, it covers a few aspects. There's the current context, given COVID, you cannot ignore that. And also, incidentally, we're on the 25th anniversary of the Constitution. Then I'll cover some brief background post-1994. And you notice I talk about the Constitution because I don't talk about South Africa prior to 94 because we were in a pariah state then with the apartheid system. And then we'll look at post the Constitution, what has been happening in the last 27 years on the ground in terms of the Constitution, its transformation, ability, and the human rights impact. And then I would like to focus more, given the limited time, I'd like to focus more on the recommendations in terms of justice for whistleblowers, and then also in terms of the role of civil society post-Zondo Commission. And then I will close up with some international best practice. Thanks, Pops. So on the current context, certainly we can't ignore that we are in the middle of a pandemic. And you might recall the UN Secretary General Antonio Guterres last year called the crisis or the pandemic a human rights crisis, impacting dignity of citizens worldwide. He was also very clear that the pandemic unpacked the gaps in political, in the governance and the economic systems globally. And what we've seen is a crisis of epic proportions in terms of morals, ethics, and values-based leadership. Also, the social ills were laid bare, such as extreme poverty and inequality, unemployment, hunger, greed, crime and corruption, racism, and all its prejudices. We've seen more recently the racism at Cornwall High School in Pretoria, and I think last week the comments by the EFF leader, Julius Malema, which is really quite dangerous to the kind of society we've tried to build and trying to build. We've also seen during the pandemic the increase in the wealth of the super rich, growing to about 28%, and that's the equivalent of about 170 trillion rand. And in my view, that's a moral crisis. And we also look at the impact on the pandemic on the policy goals, the NDP and SDG, in terms of addressing the issues facing society. And then finally, the severe implications for all of this on global peace, stability, and social cohesion. Thanks, Pops. So just briefly looking at the background and some key milestones since 94. 1994 was certainly the magic moment, the Mandela moment, which heralded the Constitution and the era of a constitutional revolution with checks and balances in governance. Various policy options were put in place, such as the RDP, BE, amongst others, to achieve transforming society from the previous colonial era to one of equality and dignity for all. And no doubt in the last 27 years, the pivotal point in our country was the 2007 Polokwane Elective Conference, which saw the disbanding of Scorpions and the beginning of the state capture project. And so in 2014, the Radical Economic Transformation, 2016, the Public Protector Report on state capture. And then during that period, we've seen the resurgence of civil society activism post-94, calling for the former president to step down as this happened under his watch. And then came 2018, the period of new dawn, hope, good governance and ethical leadership under incoming President Ramaphosa. And he started off with various commissions of inquiry, including this, the Zondo State Capture Commission. And just around at that time, I then joined the presidency and SRU on helping finalize the National Anti-Corruption Strategy in 2019, which was implemented last year. And then 2020 saw the onslaught of COVID-19. And then despite all the commissions of inquiry, we've had COVID corruption. And embarrassingly, as you all know, presently with the vaccine rollout, there's now the big question mark on the present health department on further abuses. So in terms of the constitutional era and the last 27 years, let's look at what it's shown us. So we've had various studies and reports, namely the Kalema Motlanthe High Level Panel, the 27-year democracy report by the presidency, the former Van Zyl-Slabbert report on electoral reform, the Kader Asmal report on human rights. We've seen all these reports, but we've never seen any implementation of them. Then more recently on the Zondo Commission, we've witnessed the parallel governance structures, the repurposing of the state-owned enterprises, the capture of key state institutions, and then the various testimonies, lies, denials, lies, and more lies. We've also seen more recently the threat to the judiciary, the constitution and rule of law, in terms of the former president not wanting to come forward to the Zondo Commission, but also not heeding the Constitutional Court's verdicts, and hence a renewal of civil society activism, and this led to a campaign called the Defend Our Democracy campaign by various civil society players. And the price that we are paying, it all of state capture and corruption comes to the citizen, and presently the state is paying about 1.3 billion rand a day on the interest due to state capture. And ultimately in this process, we look at the plight of the whistleblowers who've really been the true patriots and true heroes in terms of what they've revealed, and sadly, the high cost, as you've heard from Cynthia and Martha and other colleagues, the high cost to their lives and livelihoods. Next one, Pops. And then going on, certainly in this young democracy, we can't ignore the elephant in the room, which is essentially systemic corruption and state capture. And it's been estimated to cost around 1.5 trillion rand. And the question I ask, is this not a crime against humanity? Or is it a genocide of a new order? We've seen during this period the hollowing out of state institutions and the impact of states' ability to fight crime and corruption, and hence impact on the state's capacity and capability to deliver on citizens' basic services. What we'd like to see is justice and human rights for whistleblowers and citizens. And what we'd like to see is accountability and sanction for enablers of state capture and the perpetrators of crime and corruption. And in this regard, the Active Citizens Movement has played a key role and have made a submission to the Zondo Commission with inputs from whistleblowers, as you've heard previously, and we're hoping to take that process forward. And finally, we need to heed the UN Secretary General Antonio Guterres, supported by Ramaphosa, when he called this pandemic last year a generational opportunity to fix generational damages, and he called for a new social contract. Thanks, Pops. Next. So that takes me now in terms of the more key aspects that I'm supposed to talk about, which is the recommendations and the justice for whistleblowers, the way I see it. And in my view, the whistleblowers have really been the true patriots and the heroes, and they've been lauded by Deputy Chief Justice Zondo at the Commission, as well as President Ramaphosa. You might remember that Zondo himself came close to tears, and it reminds me of the TRC days when Bishop Tutu broke down. And I think what's important is, given the price that the whistleblowers have paid, is immediate relief in terms of their lives and livelihoods, in terms of families, and this talks to the pensions, the assets, and essentially the basic human rights, which are all in the Bill of Rights within the Constitution, and hence calls for urgent review of policies. I think what's important here is also the Minister Patricia de Lille, who is a former whistleblower for the arms deal, and who's spoken about whistleblowers and believes they should be rewarded financially. And I support that, and I think that the fact that they put their lives on the line, they need to be taken care of. And I think what's also important for whistleblowers going forward is looking at the work environment, a review of the gaps in the basic conditions of Employment Act. You've heard the testimony from Adila, you've heard the testimony from Martha and Cynthia, and I think the whistleblower's right to livelihood, to institutionalize good governance and performance management is critical. We also need to review the access to institutions of justice and their mandates, so that they are fair and affordable, such as the Human Rights Commission, the Equality Court, the CCMA, etc. We have all these institutions, but presently it seems like only the rich and powerful get access to courts, whereas the marginalized and vulnerable, such as whistleblowers, get a raw end of the deal. And then we also need to review the Protected Disclosures Act, which I think my colleague Willie will talk about, and the Witness Protection Act. And I think we need to institute a kind of a TRC process for whistleblowers. And in that regard, my colleague who heads up Kulamani, Dr. Marjorie Jobson, has been very useful in providing us guidance in terms of how we take this process forward. And then as we go on to the next slide on, so what can civil society do? And I see civil society as friends of the Zondo Commission. Many of them argue that they're uncomfortable with what the Zondo Commission is revealing. And my view is that I think it's a good litmus test for our democracy. It's clearly indicated that the democracy has been derailed. And I think the onus falls upon civil society, namely Defend Democracy, Active Citizens, as well as all whistleblowers, to realize the Mandela 1994 dream of freedom, equality, and dignity for all. And in this regard, as we said, the ACM have made a submission. I myself have made a submission on the human rights aspect together with the ACM, and we'd like to work with the Zondo Commission in taking this forward, together with the whistleblowers who are on the group. The other important aspect is the urgent governance and constitutional reform, given 27 years of democracy and 25 years of the constitutional order, to address legacies of colonialism, apartheid, grand corruption, and state capture. And this needs to be seen in the national interest. And some of these aspects that came out during Ramaphosa's testimony at the Zondo were issues of electoral reform, which Zondo placed to the president. And he asked what's Ramaphosa's view on the presidential electoral reform, whether it should be adjusted. And as we all know, it's a process in front of Parliament at the moment. The other important thing is delays in justice. And we've seen the Stalingrad tactics employed by the former president, but also many others, perpetrators who have been implicated in state capture. And we've seen, for example, the whistleblower Patricia DeLille on the arms deal, 23 years later, coming before the courts. And I don't think we as civil society should stand by and allow this to happen. The other question that was also addressed at the Zondo Commission was the efficacy of Black economic empowerment. And as much as President Ramaphosa defended it, I think we need to look at it in terms of how efficient has it been in addressing equality, or has it helped to create more inequality? And then we go on to the constitutional values and principles, which are in the Constitution. And I think it's up to civil society to realize the intention of the Constitution, the NDP, and the SDGs. And in this regard, we need to look at leadership, ethics, integrity. We'll look at the aspects of Ubuntu and Batapela, and especially now as the local government election is coming up, and then the next election before the electoral reform, we need to look at making sure that we have honest people in positions of leadership. In this regard, myself and former head of NDPP and SIU, Willie Hofmeyer, have been instrumental in creating an organization called Citizens for Integrity, which we are presently discussing with Active Citizen Movement as well as with whistleblowers on being part of, so we can be part of this process to fix and rebuild. And then finally, as I wrap up, given my time constraints, I think it's important to institutionalize good governance and performance management. And as we've heard, President Ramaphosa's testimony at the Zondo Commission, he's mentioned that these agreements have been signed. I think it's us as civil society to take this forward. Given the testimony at the Zondo Commission, it's not just the executive, it's also Parliament and the judiciary. We've heard the leader of Parliament apologizing, the other leader of Parliament almost insinuating that they were sleeping. And then we've seen recently the controversy around the judicial appointments. So I think civil society has its job cut off to reclaim the Mandela 1994 project. And then lastly, the UN Secretary General spoke about fixing the politics, the governance and economic systems in terms of a new normal. And I think we need to be part of that as civil society. And as I wrap up, I think what's important is to look at the world of work, given the revelation that we've been hearing from the various whistleblowers in terms of social cohesion and nation building. And we need to engage the United Nations, the ILO, and citizens at large. And my last slide talks to international best practice in terms of, firstly, Patricia DeLille's recommendation, but also what the United States has done, what the EU has done. And we need to engage with these institutions to see how we can promote a culture of active whistleblowing, but also support for whistleblowers. I'll leave you with the final comment that in my last slide, that the world is big enough to satisfy everyone's needs, but will always be too small for everyone's greed, as said by Mahatma Gandhi. And as we, as citizens, bad things happen when good people remain silent and do nothing. And I'd like to challenge everybody on this program that we need to also make sure that if we stay silent, we become accomplices. Thank you.
You can take over, bring on Willie. If Willie's going to run over, we're supposed to end at 12. At 5 to 12, we'll just do a conclusion, but we can continue after that. Over to you, Pops.
Yeah, Willie, you are a proponent of witness protection for whistleblowers. Can you please give us your perspective? And more importantly, how the state can assist in this process.
Good morning, and thank you for the opportunity. I do think that one of the things that we need to look at seriously is how we can improve the whistleblowing environment for those who are brave enough to come forward. And my suggestion, which has not been widely consulted or anything, but I think that we need an ombudsperson or ombudsman, depending how politically correct we want to be. But I think we need somebody, an institution in South Africa, to take responsibility for whistleblowing and to create an institution where people will feel safe to go and blow the whistle, but also an institution that is powerful enough to ensure that action is taken once the information is brought forward. So my unconsulted proposal is that we should set up a whistleblower ombudsman or whistleblower protector office. I would suggest that that office should be created by and staffed by 2 or 3 of the retired Constitutional Court judges, because I think those are people that everybody in the country still believe in their integrity, which is not always the case with law enforcement and other officers. So I think that essentially if one can create that kind of mechanism where whistleblowers will have trust in the mechanism, but also where that mechanism has the power to protect whistleblowers properly, but as importantly, to ensure that action is actually taken on the information that is provided. So I think one of the difficulties for whistleblowers, and which I think such an office will have to take account of, is how do you report securely? We know that we have in the past had intelligence organizations who have spied extensively on the state and those honest people in the state. So I think a secure mechanism will also be important. I think one of the issues that have arisen, certainly even in the experience of some of the people who were on the program, some of the very brave people who were part of this program, is that frankly, for a number of them, it has become too dangerous to stay in the country. And I think one of the mechanisms that has to be available for such a whistleblower protector or ombudsperson would be to be able to get people out of the country, even if it is only on a temporary basis. My one suggestion, concrete suggestion as well, is that the National Prosecuting Authority has a witness protection program that functions pretty effectively and has managed to keep people secure over the years. But at the moment, the gap there is that it is only deals with people who are actual witnesses in actual cases. And my suggestion would be that one must seriously consider broadening the mandate of the witness protection program to also accommodate whistleblowers and to make the necessary arrangement for their security. Finally, I do think that there is a lot of goodwill in this country. And I think if there is a call on business against crime, NGOs, other organizations that have some donor funding, that if we really have a concerted effort, I think one can set up that office for whistleblower protection as a sort of joint venture between the state, civil society, and others in a way that will really inspire confidence in people, in whistleblowers, that they will be properly looked after, that they will be taken seriously, and that there will be action on the information that they bring to such a body. But I think it's very important that we move fast, that we get such a mechanism in place, and that it is credible. And if we do all of that right, I think it can really make a very big difference in our ability to deal more effectively with corruption, which is still a very serious problem in our country. Thank you very much.
Willie, just two aspects if you could clear up. Recovering the monies recovered, your asset forfeiture and so on, if that is placed into a fund for all these support mechanisms that you're talking about. And the second question is, the PDA is a lot about protecting the employee from being prejudiced in the workplace. What about, and you mentioned it in your slide at the end, visiting both the civil and criminal prosecution against the employer and the perpetrator? There doesn't seem to be any mechanisms for that. And you mentioned it in your slide, if you could deal with that. And if you can just deal with those two points initially, please.
So my first suggestion was just when the asset forfeiture unit recovers money from criminals, and there isn't a victim of that money, of that crime, the money goes into something called the Criminal Assets Recovery Account. I may be a bit out of date because I've been out of the state for a while, but there's been several R100 million in that account for some time. And for me, one of the suggestions would be that if one can establish such a protector of whistleblower office, some of that funding can come from the Criminal Asset Recovery Account to facilitate that process in the beginning. So that's the one concrete suggestion. But I do think that one also needs to look at a much broader initiative between, involving people like Business Against Crime and other role players to actually raise money to support this kind of initiative. We do know that the state is in pretty desperate financial straits at the moment from all the stealing that has happened. So I do think the solution that we're looking for does need to be a sort of joint solution between the state, civil society, and the progressive business organizations that there is.
Okay, and the question of criminal and civil sanctions against perpetrators.
I can't say that I have looked at that very properly in terms of what the legal dispensation in other countries are. But I do think that's a very good suggestion that we should be pursuing, particularly the civil litigation, civil law remedies may be easier to do than the criminal law remedies, frankly. We all know that the criminal justice system is under some strain and it takes a long time to get things done.
And the
But
test
I
is,
do think that we should be pursuing both of those options and see what other countries, I think there are some models about what other countries have done in this regard.
the criminal test is higher beyond reasonable doubt, is another aspect.
Indeed, yeah.
Two other things, if you could touch on very quickly. One is constitutional damages. I haven't seen anything where they say, look, there's such gross abuse, we're visiting constitutional. It's just restoring you, not punishing with constitutional damages. Is that available or not? And the second one is the legal costs. You know, if you take Adila's case, Lamberti was lumbered with some of the costs personally, but jointly and severally with Imperial. So Imperial pays it, and presumably he doesn't pay anything. That's one. And secondly, if he did pay something, all the directors probably have an insurance policy to pay it, so if nothing comes out of his pocket. So that seems to be a bit of a safety net, and that doesn't solve the problem either.
Mm. Yes, I do think that is a real problem, is that very often the perpetrators, the actual person who did the wrong, comes off scot-free because it's an institution that has to pay the damages. My sort of thought on that issue would be that if one does look at establishing the office that I'm suggesting, that office should be able to make financial orders against the actual perpetrator in his or her personal capacity, not just that it's a company or other body that is liable for the money. But I think that's a very important point you raise, is that we do need to affect people who does this wrong in their pockets, if not putting them into jail, which is obviously the better option.
Well, Pops will talk of the orange overalls, so let's leave that.
Yes.
Thank you very much. Look, I think we just need to end, and we can come back and continue, but those who want to leave might want to leave, so just to be fair to them. We did advertise to finish at 12. So the formal program will end, but if there seems to be interest and we can continue, we also need to do the international aspect. So I would like to thank our hosts, AMAL and ACM, and Al Baraka, your partner bank, who provided this webinar facility. Shabir Chauhan, the CEO, who's not too big to personally act as the tech guy for the show. Adila Chauhan, Cynthia Stimple, Norma Ngoyi, all whistleblowing heroes. Fani Dingiswayo, Shivera Dev Vachandar, Willie Hoffmeyer, all of whom graciously stepped in at the 11th hour. Thank you very much. Crystal Selamaya, Pops Rampersad, and Fatima Lockett for smoothly moderating things. But most of all, a shout out to the viewers. This cannot end here. There's a long and winding road. And if we want to save our democracy, I'm going to leave it to Pops, who, like my wife, always has the final word in our discussions. Pops, if you can unmute yourself and we can...
With the difference, I'm not as pretty as Shamima is. But thank you again, Aslam. I don't think it's a close-up because, if we can, there are many questions, and those that are on the panel, I think, they're welcome to take the questions. But I just want to reflect a little bit on some of the work that we are doing around, the ACM is doing around the issue of whistleblowers. So on the 28th of April 2021, President Ramaphosa, in his closing remarks on behalf of the African National Congress at the State Capture Commission said, I quote, "I wish to conclude by paying tribute to all the South Africans who played a role in unearthing corrupt activities that we now know as state capture. Here I make reference to those who be whistleblowers, and whistleblowers have not had a great time in our country. Once they blow the whistle, they have been subjected to enormous pressure, pressures that have affected them personally, professionally, career-wise, and also affected their own household. They have been brave men and women of the country who, because of their abhorrence of corruption, blew the whistle, and I regret that in many instances, we have not treated them well. And we therefore need to have some process, legislation, for being able to protect whistleblowers. Based on that, ACM put out a petition. And in a month, we only have managed 1,140 signatures, and which is a bit disappointing, considering how much we should appreciate whistleblowers. So that can be shared with AMAL and get more signatories on the petition. But we have decided as an organization, together with whistleblowers, to say to the president, enough is enough. You got to walk the talk, and the time is now. So when he appears the next time, and we really don't know when the next time is, because the State Capture Commission has asked for a 3-month extension, but we know that the president will be the last person to give a testimony. So on the first day of his appearance, the Active Citizens Movement, together with whistleblowers and other civil society organizations, will be staging a protest outside the State Capture Commission, calling on the president to walk the talk and to support our whistleblowers. And in the meanwhile, ACM continues with its Friday.
Pops, you're going to
will continue on
observe protocol at the protest?
Well, the protocol is through it will be through invitation only. We will open it up if we go to lower levels of lockdown, but at the moment as we stand, it's only going to be those invited participants. Also, when the lockdown moves to lower levels, we will continue with our orange mask campaigns. We'll announce publicly when it will be held, and we're hoping that many people come and join us. There's the mask that Aslam is wearing. He'll make a good model. And I've got the t-shirt, and earlier on you saw the mask. So we've got posters. You can't see behind me a poster. I think it's probably inverted, the print, but that's what we have done in the meanwhile. And we're looking for more South Africans to get involved in this campaign. It's not a political campaign, but every South African, patriotic South African, should get involved in eradicating corruption in our country. Thank you very much. And the ACM contact number, should anyone wish to contact us, it's 067 007 7132. 067 007 7132. Our email address is active, ACTIVE, MSA@gmail.com. I think I've got it right. If I haven't, can someone please post it on the chat? activecmsa@gmail.com. We'd like to engage with you. Thank you.
Pops, you just hijacked the show from AMAL, but okay. I'm going to ask Pops, after I'll bring on Cynthia, and after that, if you could help with the questions, because I can't see questions. I'm going to ask Fatima to help me, but if you could check the questions and bring in people, please, if you can attend to that part, because I'm not sure how to do that.
I've got two questions, Aslam. If
let's first bring on Cynthia.
That's fine.
Cynthia Stimple could come back on. Due to time constraints, Cynthia, if you could just deal with the overseas legislation as it relates to USA and UK, and not go to all the others, because we'd like to field the questions that have been put on. Thank you.
Thank you very much, Aslam and Pops. I'll just give you the US current legislation. They have the USA Securities Exchange Commission, which you normally hear as the SEC, and they provide monetary awards to eligible individuals who provide original information that leads to a sanction order in excess of $1 million. So once people have given information and they investigate, they're able to sanction it, the award to whistleblowers is between 10% and 30% of monies collected. They also have an additional legislation called the USA False Claims Act, which allows people to provide information, but should this information not be backed by truthful evidence that they could investigate and find that it's correct and truthful, the person would then be prosecuted. So they cannot go and tell lies. This is designed to prevent vindictive people laying false claims. On the UK front, they have a compensation act which assesses the losses the person suffered. There's no reward for disclosures as such. Requirements include that the disclosure is of a type that is protected and made in the public interest. The large payouts are possible depending on the nature of the losses claimed, and suffering detriment includes being denied training opportunities or demotion or not being promoted or losing anything in your job. Compensation for injury to feelings can also be claimed, but not unfair dismissal. They keep that separately in a labor legislation. Essentially, the US rewards whistleblowers while the US is perceived again that it's not as lucrative because it only compensates for losses. Do you want me to talk about the Netherlands, or there I can stop?
Yeah, no, I just want you to also deal with the Netherlands because it actually goes much further. And it's not just limited to corruption. It talks of climate change and so on, which is so important. And Pops will tell us that another very important part of ACM's campaign. If you let him go, he'll carry on plugging that. So we'll just deal with that as well, please.
Thank you. So the Netherlands have, I translated, it's actually called for Klokkenleider in Dutch, but it's the home for whistleblowers. And I think that would be something South Africa can peg or look at how we want to run ours. So they have this Whistleblowers Act, which allows public and private sector employees to report regulatory violations on health and environmental risks, on everything, and threats to the function of public services and companies. They also, their authority, they call it the Dutch Whistleblowers Authority. They provide advice and support for employees to report a possible wrongdoing. They also conduct independent, confidential investigations free of charge. The Act obliges further, it obliges larger companies to have a procedure for reporting internal wrongdoings. And although established and funded by government, by the Dutch government, it is independent from any ministry, similar to our Chapter 9 institutions. So that's something I feel we could possibly look at. Then if I can just go with the current European Union, because they are so diverse, they've now set up a whistleblower protection directive. And every country under the EU has to comply by December this year, 2021. I think Slovenia is one of the first countries to have complied so far. Germany is not even there yet, so we have to wait and see. Whereas they then look at promoting secure ways for persons in the public and private sector to report misconduct in their work environment. And then I chose one in Africa, Ghana, because they have a whistleblowing act, but at the moment, they have it's considered the strongest legal protections on paper, though, in Africa, but it's also not that good in practice. The Act provides legal protections and remedies to all people, so whether it's an employee or a citizen, and who can report misconduct in the public interest. Thanks.
Thank you very much, Cynthia. Pops, if you could take over, you had some questions to field.
If I could just assist, it seems that our panelists have been very helpful in answering some of the questions that have been posed online. There doesn't seem to be any open questions, but Pops, if you have anything.
Yes, I'm looking for them. Just two questions, and there were some on the chat group I will get to now. let me just look at my phone. The two questions I have. Perhaps a question for accountants and auditors. Should the annual reports of companies include the number of transgressions related to corruption, stroke malfeasance, and what actions should be taken, have been taken, just for the accountants and auditors, but I think anyone can respond. To our whistleblowers, what is your message to President Cyril Ramaphosa, who during the closure of his last appearance, I mentioned what he said. What should he be doing as a president of South Africa to demonstrate that he walks the talk? Okay, and then maybe a third one. It's a very lonely place as a whistleblower. What are your thought process prior and post blowing the whistle? What are your immediate concerns after you have blown the whistle and how you deal with it? And what are your expectations after you've blown the whistle? 3 questions there, and I'll follow up with some that's on the chat group later.
If I could just add to that question, perhaps if I could just amplify to that question. Praveen told Cynthia, you're a hero, fantastic, and so on. She unfairly dismissed. He's got some influence in SAA. You're saying that our president should walk the talk. Surely Cynthia should have been given her job back, or possibly a position on the board. If you want to fight corruption, why not that? Pops, you've disappeared.
I'm here, but are we? Sorry, I'm still around, but we're waiting for those 2 questions that I've posed, or maybe the 3.
Well, can you direct it to somebody and ask them to answer? We've got our panelists.
Cynthia, maybe you can tackle the one on the pre and post whistleblowing thought process. What's your expectation post blowing the whistle?
Okay, so
any accountant or auditor can answer the question relating to annual statements of companies. And the reason I pose that is because very often companies appoint third-party whistleblowing facility where you log your complaint. That whistleblowing facility doesn't do any investigation. It's handed back to the company who does the investigation, and very often or not, they don't release the report. I have a personal case regarding my former company, and I need to talk to some lawyers after this. How do we get the report? Because that company awarded a contract to Bain, and it's in the public domain that may have been some malfeasance on that contract. So I think if one digs around, you'll find a lot in the corporate world. There's a lot of corruption that goes on. But Cynthia, sorry for this making you hold on, but you can continue now.
Okay. So I'll answer on the one. So we've all, the experience of a whistleblower is a lonely journey. It's unfortunate that our country, our neighbors, our friends do not yet see it. You only afterwards realize the difficulties, but at the time you find that your colleagues will treat you as a pariah, push you out, nobody talks to you, and hence why the journey is a lonely path. And until much later, people realize what you've gone through. What did I do? I found ways, as Adila also said, she had to reinvent herself. I did similar, where I also went to study further. I studied the board exams as a board of director in order that I could then be on a board to have more ethical boards, because I found just going through all the cases with Transnet, Eskom, Denel, SAA, it's at board level where the shenanigans were being perpetrated, and I felt that's where I could influence. So yes. Secondly, I did what I love and what my passion was, which was yoga, and I went to study to become a yoga instructor for both adults and children. And so I do that because that gives me meaning to life. So I would recommend most whistleblowers find what they're passionate about and follow that route. We all do suffer financial loss, and not every method will bring us in funds. We cannot get jobs. Most of us still haven't. Some of us can get part-time work or ad hoc work. And so we go for that. But when you change your mind, like for me, I don't ever want to work in a corporate again unless it's my own business. And so you have to then find other avenues. So what would we like to get out of this? I would like that every whistleblower is recognized, and recognized financially and via some form of award system. Reason being, there are whistleblowers who have been murdered and killed, and their families have suffered, and no one even knows who they are. Most of those names came out in Mandy Wiener's book, The Whistleblowers. I know of one in Cape Town in Parliament who committed suicide, left a suicide note saying, I'm doing this in protest for what's happening in Parliament. This is under Zuma's days. And his story has been so quiet. It's all those unknown whistleblowers. We need to recognize them. We need to create some mechanism that their names go on to eternity. Their names should be there for the future to know what these people have stood up. And then obviously, I think all of us would agree on financial. I listened to Themba Maseko the other day. I liked his thoughts that he said he doesn't go with a reward, but he goes with financial assistance. And that too should be taken into account. And that I feel needs to be debated, because we all have different needs as whistleblowers. But not only that, some may have families, larger families, that 1 million may not be enough for the person who has children who need to go to university and are still very young and they have the schooling ahead of them. So one needs to look and assess those. If I may end there, but it's broad. We also need psychiatric help, psychological help, psychoanalytical help, social worker, trauma counseling. And we all need to find some way we can have our own dignity. And that's through getting a job. And how do you get it if you can't reinvent yourself? Thank you.
Thank you, Cynthia.
Pops, I want to pose a
comment.
Pops, I want to pose a question to Willie, because of his government background, because of his ANC background, but it's not a personal attack against him, but having that background, he'd be able to inform us. Cynthia's personal Via Dolorosa proves that there's so many complicit actors, starting from the Parliamentary Oversight Committee, right through other bloated, overpaid government institutions, seemingly more concerned with fighting each other in exorbitant legal battles at taxpayers' expense. And then also the public, you know, what are we doing to support whistleblowers? We've been silent. I see Crystal said, you know, blowers vuvuzela and get us up. You know, when Dudu Moyeni gets chopped, we all get happy and we think that's over. But the whole corruption infrastructure rot is left intact. And how do we get rid of that? And yeah, Willie, if you could address that, please.
Yeah, I suppose that is the big challenge. You know, my own sense at the moment is that we probably do need to look seriously at setting up a single overall anti-corruption agency, which some people have been pushing for. And I think that, you know, I've had my doubts about that in the past, but I do think that at the moment, law enforcement is sort of very split. You know, there's murders, rapes, all sorts of gruesome crimes that the public want action on. And it, in a sense, that becomes the main focus for law enforcement is to focus on those issues. So I do think that we should be looking seriously at a single anti-corruption agency, which does not take responsibility for any crimes other than corruption. But I think then also would be a very logical place to deal with whistleblowers or to make provision for whistleblowers in such an institution. But for me at the moment, we're just not giving enough high quality focused attention to dealing with corruption and all the related issues around that. And I think it's vital, if we're going to turn things around in our country, it's vital that we really get down to look at how we deal with it more effectively in the future.
Willie, while you're there, there's a question from Professor Yusuf Vauda. He says, my question relates to the security of whistleblowers. While proposals like an ombudsman to independently investigate complaints are vital, what about the existing institutions which are failing to protect them? The NPA has made slow progress on prosecuting those implicated in corruption. There are serious allegations of corruption in SAPS and allegations of collusion with even criminal networks. Should civil society address these issues? Your comments, please. And how?
Now, I do think it's important, or the pressure that civil society has put on the state over the last, I'm not sure if I'm going to say 5 years or 10 years, but I think civil society has played a really important role in putting forward proposals and pressurizing government to do things better. And I don't think we must lose that momentum. So I think the role of civil society does remain very, very important. I think, I'm also a little bit involved in supporting some of the whistleblowers in SAPS itself at the moment that are being victimized for exposing wrongdoing in SAPS. So there's definitely things that we need to do to ensure that law enforcement itself remains clean. And one of the things I've been sort of lobbying for is a much more effective system of checking on the integrity of law enforcement to make sure we know bad people have been appointed in the past. We just don't always know who they are. So I think some sort of pressure from civil society to ensure that there is a much greater momentum to ensure that the integrity of those involved in law enforcement are tested regularly and properly and independently by people who are not in law enforcement. And I think that is for me one of the things that can make the biggest difference in all the things that we're talking about here.
Shouldn't there be a body that looks at a matter and decides whether legal funding should be provided by the state for state employees? Because that seems to be one of the biggest problems, that there's unlimited funding. If you take Zuma, he's got a Gucci dream legal team and make sure he never gets the day he wants to in court. If that is stopped, I mean, you assess it, look at it. If there's a fair case, it's got a fair defense, fine. The state should throw money at it. But if it's clear cut and that the person is guilty and of some wrongdoing, there should not be this endless funding. It should stop. And that is one of the ways we're ever going to get rid of corruption.
Yeah, I think that's a very good point that you're making. And, I suppose the problem is the state ever going to limit the of its own accord, going to limit the money made available to defend people who were colleagues before. So, I mean, I've not thought about this issue, but I think it is a very important issue. And perhaps it should be a similar thing to what I was suggesting around whistleblowers, that you have some sort of credible, independent people who actually makes the assessment of whether the state should be funding people in law enforcement who are charged with criminal activity. Because there certainly has been a number of those sorts of cases, and I don't think that's how our taxpayers' money should be spent.
If you look at the public protector, there's like a serial loser of cases, and money is just going, and it gets appealed, ends up in the constitutional court. It's enormous amounts of money being spent, and they say decision is irrational, and that goes on appeal.
Yeah. No, I mean, I think that is one of the most worrying things, is when our public protector is in that kind of position. But we also, I suppose, know who appointed her in the first place, so we may not want to expect other things from her.
Pops, have you got more questions? Or
Yes, Martina has been unmuted. Can you please come on with your question or comment?
Hi, my name is Martina de la Tonya. I'm a whistleblower from the Parliament Administration. I'm one of a group of 8 former managers at Parliament that stood in support of Lennox Kagane, who was the gentleman Cynthia referred to, who committed a protest suicide, which is an unprecedented event in South Africa. I mean, and a very deep and meaningful one. It was fairly well reported, but the challenge we have with understanding how Parliament works is that there isn't enough public understanding of the distinction between the Parliament Administration, which runs the institution in support of members of Parliament who are meant to play an oversight role. And the interesting thing to note is that Parliament staff, and I'm talking about the professional staff, not the politically appointed officials in the office of the Speaker and the office of the Chairperson, but the professional staff who run, the committee meetings, setting up the infrastructure and the support that members need to conduct their work, are not protected by the Public Service Commission, and are seen as in fact, the Public Service Commission has indicated that they don't have jurisdiction over Parliament officials. So whilst it's a fairly small number of officials, I mean, managers in Parliament constitute about 200 out of the 1,200 employees of the administration of Parliament. If there is no recourse for those managers and officials if they come under pressure, and if they feel, and as a result, even the parliamentary testimony that has been heard in the Zondo Commission hasn't seen a long line of former officials and current officials reporting on the shenanigans that happen in Parliament consistently, even in the 6th Parliament. And for me, if you don't fix Parliament and you don't broaden the understanding of how Parliament itself is overseen, if you don't have an understanding of the Financial Management of Parliament Act and the fact that there isn't an ombud to protect those staff members, it creates such a toxic environment where officials are very vulnerable to public representatives. So, I, for example, stood accused of organizing a middle management revolt against the former Secretary to Parliament, which took about 3 years to deal with. I mean, eventually the former secretary was dismissed unanimously by both houses, but it doesn't account for kind of the literal bloodshed that was blood that was shed at the institution. these are very uncomfortable conversations. I mean, it's not just Lennox Kahane who committed protest suicide. There were a number of people. If you look at the HR statistics within that institution, and how many people have left, and how many people have suffered quite a lot of ill health due to the toxic environment in that space, and the bullying that happens as a result of staff needing to be coerced to do things by members. It's just an area of knowledge that I find is very limited in the even amongst law professors, by the way, in my experience. So yes, I just thought I'd draw the attention. I don't know who's all in the seminar. I've just joined lately, but I always use whatever opportunity I have to draw attention. If we don't fix Parliament, then Parliament's not going to conduct robust oversight over even the law enforcement agency that Willie is talking about, that are meant to play that role. So we need to fix the entire state, you know, all arms of the state. And the first part of that is knowledge. Thank you.
Thank you, Martina. Can you please contact, get in touch with us either by email or the number that I've on 067 007 7132. I think there's a lot we can discuss, and you can be part of our whistleblowers group as well. Looking forward to your involvement. There's some lovely comments here from people. Not many questions I see, but I think a great concern arising from the fate that of whistleblowers post their whistleblowing activity, and it shows that we need more of civil society to get involved. And we're just hoping that through these webinars, and what I noticed from today's webinar, you know, we can talk the whole day on this topic. So there's not enough time, but perhaps we have to have regular webinars on this topic to get more of our society to participate and to support whistleblowers.
Pops, if I could just read one or two testimonies.
Okay.
Which
you want to read them?
Yeah. You know, Fatima, are you there? Fatima?
Yes.
Can you just tell us about Moses Parkway?
Sorry?
Moses Parkway, can you just tell us what his testimony is briefly?
ANC municipal councillor was exposed to corruption in the municipality within political challenges of the ANC. Sorry, the political channels of the ANC, excuse me. He handed the dossier to an official. 2 days later, he was killed. Walmerans was convicted of murder. The dossier of Moses then went missing, but was found in the home of former intelligence boss Richard Ndluli.
I'll tell you about Dr. Theron. Dr. Theron was employed by the Department of Health at Paulsmoor Prison, suspended after disclosing the poor state of healthcare at Paulsmoor to Parliament and the inspecting judge for prisons. The Minister of Correctional Services sued him for defamation, which were dropped. Theron got to a court order to return to his post, but the guards at the prison physically blocked his re-entry. Parliamentary committee confirmed his complaints, but even after a long and expensive battle in the Labour Court, he was never reinstated at his post at Paulsmoor. If you could tell us about...
Sorry, I think there's one of the attendees, Marcus, who would like to say something.
Okay, let's just finish Ismail Muqaddam, if you can just tell us his testimony.
So Ismail Muqaddam was a shopkeeper who complained to the Competition Commission about the collusion in the baking industry. Bakers collectively reduced discount to distributors. The Competition Tribunal found Pioneer Foods, Tiger Brands, and Food Corp guilty of breaching the Competition Act, and they were fined over 90 million rands. Producers withdrew business from Ismail, resulting in his business failing. He now works on consumer fairness, continuing to pursue justice for the public good.
Okay. I'll just read one
I
more.
may just add there. Sorry, can I just add to that one? The irony of that collusion is that the current CEO of Tiger Brands was involved in the collusion activity. And he's been appointed CEO of Tiger Brands. I mean, you know, he gets rewarded for colluding.
I think, yeah, so the point you're making, Pops, is that it's also in the private sector that civil society has to be vigilant. It's not just in government.
Correct.
I could just read one more. Mike Shonga, internally disclosed corruption and nepotism in the liquidations at the master's office. He had no response, so he went to the media. He was suspended 2 months later and had to litigate and fight his unfair suspension in the labor court, where he finally reached a settlement. Mike says that the attitude of the Minister of Justice shows that there's no political will to root out corruption. Now, POCA makes it compulsory for state employees to disclose corruption in the public service. Yet, when they do so, they're often destroyed. Over to you, Pops. I think somebody had a question, I think.
Yeah, there's two more. I think they have been unmuted. So if they can come in,
hello. Sorry,
Marcus and then Billy, I think, again. Come,
yeah,
Marcus.
hi. It's Marcus Turin speaking. Mine, I suppose, is more of a comment, and it's this, that both the PDA and the Employment Equity Act allow for damages. Obviously, the PDA has a very codified situation in which damages can be claimed. So you'd have to show that you were subjected to an occupational detriment on account or partly on account of having made a protected disclosure. The test under the Employment Equity Act is not as strict. And what it does is it allows for an employee, obviously it's strict in the sense that it's confined to rights that are set out in the Employment Equity Act, but anyone who is prejudiced, and that's the language of the Employment Equity Act, anyone who is prejudiced as a result of having exercised rights in Section 51, and that deals with the protection of employee rights, exercised any of those rights, including the right to make a disclosure of information. So it doesn't talk about a protected disclosure, it talks about the disclosure of an information. It can also use that law to claim damages. Now, I think that's a very important provision, because that's what, in theory, should restrain employers from seeking to harm or retaliate against whistleblowers. So I think it's important to bear those two provisions in mind. The PDA was amended in 2017, and fortuitously so in my case, because had that not been the case, I would not be able to sue Wits University using those provisions. But as I say, fortuitously it has been amended, and I'm now able to use that provision to seek damages. The problem is that these provisions have not been used very extensively before. In fact, I can come across no cases under either the EDA or the PDA itself. And I'm not referring here to the way in which Adila pursued her matter in the High Court, but to use that provision in the PDA that allows one to sue an employer for damages. These have not been used before, and I can find no case law. I suppose part of my problem is that I'm doing all of this myself, and I'm not a lawyer. So yes, I think just my point was just to remind people that there are those two recourses that people have, of course, in very defined situations. Thank you.
Thanks, Marcus. I think there's a common theme amongst whistleblowers that very, very few lawyers understand all the opportunities available to them. And I think one of the problems is that you've got to hunt for it here, there, in about 5 or 6 different acts, and not contained in one thing. But that's a common complaint that lawyers do not understand the remedies that are available. They're not whistleblowers haven't been served by competent lawyers in general. You mentioned the university, which leads us to one of our team, Athol Williams, also. He joined Baines as a partner to lead the company's effort to make amends for its involvement in damaging SARS. And yet, Baines impeded his investigation, hiding the truth, and he also ended up losing his job for blowing the whistle. Back to you, Pops.
Thank you, Aslam. I think, we would not do justice to this kind of webinar if we don't make an impassioned plea to the professionals out there. And in this case, I'm talking directly to lawyers and advocates. This is what whistleblowers are crying out for: pro bono aid. And I don't want to, AMAL should not bear the burden themselves, but since we are partners in this, I think it'll be a good start for us to have a discussion as to what assistance the lawyers or the legal people within AMAL can do to assist some of the whistleblowers. We have a tight group of whistleblowers. ACM is very, we screen them. So it's not anybody who claims to be a whistleblower becomes a whistleblower. So we screen them to ensure that they are legitimate whistleblowers. So again, or through Aslam, we are looking for this assistance, and I'm sure
ACM,
all whistleblowers are going to give me a shout out there, because this is what you have been asking for.
I'm wearing the ACM hat.
I think Willie has a comment to make as well.
Just on that specific question, I think the idea of that I put forward of a sort of former constitutional court judge being almost a kind of ombudsperson, I think that would help a lot, because I think if somebody like that phones a law firm and say, can you give some pro bono assistance for this particular case, it really does make, having worked in a law firm myself, I think it really does make a big difference about who it is that's requesting it. If it's just the whistleblower, they're not really, they're not an important or recognized name, or there's little credit that you will get out of it. Whereas if you're seen to be acting on behalf of this ombudsperson, I think law firms can get some credit for doing that. So, I do think that's something where we should be putting some effort into is about creating that kind of mechanism, both to give some credibility to the whistleblower investigations, but also the weight it carries when a law firm gets a call to say, could you do a pro bono assistance for this particular person? So I think that.
Sorry, carry on.
No, I was just saying, I think that's something that's worth thinking about as well. That it depends a lot who the people are that phones a law firm to say, can you assist in this case?
Well, you can then, it's a credible complaint and not something that's not valid. Pops, if ACM could crowdfund some money, I undertake on behalf of AMAL lawyers to assist. But I think, look, we've reached the end. We've got to end by 2:45. If you can just wrap up for us, Pops, and we can call it a day now.
Yeah, once again, on behalf of ACM, I want to thank AMAL. I want to thank again Aslam for the the hours that he's put in and the last minute withdrawals and changes up to this morning. So fantastic job, Aslam. Shabir from Al Baraka and Amal, our heartfelt thanks to you. To our audience for giving strength to our whistleblowers for the work that they have done, for giving strength to ACM, and you know, it makes us want to continue the work that we want to do with whistleblowers. South Africa is not free until whistleblowers are protected, and this is what we need to understand and what we need to work towards. I don't think government has got the appetite to deal with it. So it's left to civil society organizations like ourselves to get involved. Once again, thank you. You will be hearing more from us, and enjoy the rest of the weekend.
A luta continua.
A luta continua indeed.
Thank you. Bye.
Bye.